In the Logan Paul v. Coffeezilla defamation lawsuit, the two sides have been in a big fight lately over whether Logan Paul can have access to Coffeezilla's communications with his editor and with his computer graphics artist. Logan Paul says he's entitled to these communications as part of his efforts to prove his case. Coffeezilla, however, says they fall under the journalist privilege under Texas law. This one is an interesting one, and I actually don't know how this is going to result because there are a few open questions as far as I'm concerned. Let's get into it. Okay, so over the last 6-ish weeks, we have been about knee deep in moving from one country to another, which means that I have had to pause content on the channel for a little bit. It also explains why I'm recording this video while sitting on the floor in my new office, because I have no furniture in my office as of yet. Anyway, in that time, a number of things have happened in this case, so I'm trying to get some videos out about it sooner rather than later so that we can all get caught up with what's going on here, furniture or not. And as always, if you are new to this subject, there is a link in the description below to a playlist of videos that can help you get all caught up so you can get the context of what is going on in this whole lawsuit. Otherwise, let's get some updates. One interesting fight that's developed between the two sides is this argument over whether Logan Paul has a right to communications between Coffeezilla and his editor and his computer graphics artist. Here's what this fight is all about. On August 6th, Paul filed a motion to compel production of communications to and from Harry Bagg and or Ed Liszczynski. Bagg is Coffeezilla's editor and Liszczynski is his computer graphics artist. More specifically, Paul says that he's trying to get communications between them relating to Coffeezilla's statements that Paul says are defamatory. But Paul filed this motion because he says he's been trying to get these communications from them, but that Coffeezilla is saying, not so fast, they're protected by the journalist privilege, so you don't have any right to them. Now, before we go any further, I want to explain something about litigation discovery that is important to understand for this overall argument. But first, I have to thank this video sponsor. This video is sponsored by Rocket Money. I don't know about you, but I have a terrible habit of signing up for some subscriptions for some kind of a service under some sort of a special deal and then promptly forgetting about it until months and months later after I've wasted a ton of money and maybe not even used the service to begin with. Well, the good news is Rocket Money can help with precisely that kind of thing. Rocket Money is an all-in-one personal finance app that helps you cancel subscriptions, lower bills, and manage your money better. For me, the best part of the service is to help eliminate those unnecessary subscriptions. You connect your bank account and Rocket Money identifies all of your subscriptions in one condensed list. This allows you to see everything that you're paying for at a glance. And then you can select the ones that you don't want anymore, and depending on the service, Rocket Money might be able to help you cancel those with just a few taps. Now, aside from that, Rocket Money will also automatically scan your bills to find savings. And then they can help negotiate your bills for you, from internet to cable and phone bills. This is saving you not just money, but also time. And they can do more, help you save money, set budgets, and even automate savings. So if you're out here thinking you could use a little bit of help with your financial management, check out Rocket Money. To save more and spend less, join the over 5 million members using Rocket Money today. Go to rocketmoney.com/legalbytes or click the link in the description below to get started for free. And thanks again to Rocket Money for sponsoring this video. Okay, back to the video. So in order to understand some of this back and forth between the two parties over these arguments, let me explain a couple things about litigation discovery. Normally, when we're in litigation, discovery is very broad. When you're a plaintiff or a defendant to any kind of a lawsuit, the other side is able to get access to information that they generally otherwise would never be able to get even close to. We're talking financial documents, medical records, phone records, you name it. If it's reasonably calculated to lead to evidence that can be admitted at trial, the other side is generally speaking entitled to get their hands on it, with very few limitations. And those limitations mostly revolve around privileges. These are a handful of essentially security walls that the law says that the other side is not allowed to cross. Those are things like the attorney-client privilege, conversations that you have with your lawyer where you are trying to get legal counsel. They also include the clergy penitent privilege. For example, if you are a practicing Catholic that regularly goes to confession and you go and you confess to a priest to having done something that is illegal or unlawful, the priest that you confess to cannot be compelled to testify about those conversations. The same thing exists for married couples. Of course, all of these privileges have their own nuances and limitations, which we don't really need to get into in this video. More important is that there also exists a privilege for journalists to protect their sources of information. And something to keep in mind with all these privileges, by the way, is that there's always something specific that the law is trying to protect or to promote with each one of these privileges. For example, the law wants to encourage people to be as forthright as possible with their lawyers so that they can properly represent them as they're entitled to under the US and states' constitutions. It also wants to protect bona fide religious practices like confession under the Free Exercise Clause of the First Amendment. And it also wants to encourage married couples to have open and honest and intimate and healthy relationships with one another to build lives and families and everything else. And the law also wants to ensure that in order to protect robust journalism, which is also foundational to the First Amendment, that we protect the sources who provide information to journalists so that they have news to report on. This is because if it were the case that in any litigation, anyone could compel a journalist's sources, that could cause a massively chilling effect. This is especially when it comes to the more important stories, the ones where maybe a singular individual is showing an immense amount of courage to speak up against powerful forces that can cause all kinds of harm to this individual. Bottom line, if a source can just be given up in litigation, people will just stop talking to journalists. And then we won't have any free press whatsoever, whether in legacy media or on social media. But now at the same time, keep in mind, a journalist or a journalism outlet also can't just hide behind this privilege to hold back information that otherwise should go to the other side. So when it comes to journalists in litigation, this is a privilege that is likely to come up in a case, particularly a case like this, because the sorting of information between the two sides is bound to come up against where this line is drawn between discoverable information and protected information. Okay, so with all of that said, let's dive a little bit deeper into what is specifically being argued here. So in his motion to compel, Paul makes two main arguments for why he should be entitled to this information. First, he says Coffeezilla waived this privilege because he failed to identify the communications at issue in his privilege logs. What Paul is referring to here is that when there's some evidence that the other side wants, but you think that it is protected by some kind of a privilege, you need to identify it on essentially a chart. Now, there's generally a certain level of detail that you need to give when you put something on a privilege log. And that's because this is supposed to give the other side an idea of what it is that you're withholding, but without giving them access to the substance. And so here, Paul argues first in his motion to compel that Coffeezilla didn't put these communications with his editor and graphic artist on the privilege log. But Coffeezilla says in his opposition, that's not true. I listed communications with my team in there. But now Paul says this isn't good enough. It's not enough detail, and therefore Coffeezilla waived the entire privilege as to these communications. Now, I don't begrudge Paul's lawyers for making this argument. If I were in their shoes, I would probably be making the same one myself. In litigation, you often make the most forceful argument that you can in the interest of representing your client. But I also know that when it comes to discovery, unless one side is being like habitually sneaky or duplicitous, I find it a little bit hard to believe that a judge is going to say that a whole privilege has been waived just because it was identified on a privilege log, but maybe not enough detail. In my opinion, more likely is that the judge is going to care more about the other arguments that the two sides are making around this issue. So let's talk about those. So the second part of this argument is over what Logan Paul needs to show in order to overcome Coffeezilla's assertion of this privilege. This is all under the Texas Civil Practices and Remedies Code, which gives 6 points that Paul needs to meet. Now, as a side note, one thing Coffeezilla notes is that there isn't actually all that much case law in the statute, which means that there isn't much guidance for how this should all be analyzed. And that, in turn, increases the level of uncertainty as to how this judge is going to come out on this issue. But anyway, these are the factors. First, Paul has to have exhausted all reasonable efforts to obtain the information from alternative sources. Now, realistically, we are talking about communications between 3 people. And Paul says that if these communications are privileged from Coffeezilla's angle, they're going to be privileged whether they come from him, the editor, or the graphic artist. Coffeezilla, in his opposition, however, said that Paul needs to give more of a showing that he tried other ways to get this information. But on this point, I actually do agree with Paul here. It's going to be kind of pointless to try to get these communications from the other 2 guys involved in these communications here, because Paul is going to need to use a subpoena to get those from them, and when he issues a subpoena, he's likely to get an objection from Coffeezilla and probably using all of the same arguments. Anyway, the second factor Paul has to show is that his request is not overbroad, unreasonable, or oppressive, and where appropriate, that it's limited to verify published information and surrounding circumstances related to its accuracy. And in this case, it looks like Paul is seeking the communications between Coffeezilla, his editor, and his graphic artist for communications about Cryptozoo. And so based on what I've read here, under circumstances that don't involve privilege, Paul would probably be entitled to information that responds to a request like that. It is pretty routine in litigation to request basically everything that an opposing party said about the events or issues involved in litigation or the litigation itself to basically anyone. I mean, that's how we have Logan Paul's petty billionaire text between him and his friends. So looking back at this situation here, there's nothing here that tells me that Paul is making an overbroad request as far as it relates to the issues that need to be proved by the other side. Anyway, the third element Paul has to show is that he gave reasonable and timely notice. According to the arguments by both sides, it doesn't sound like there's really any disagreement here, so we can just leave that one at that. Okay, so fourth, Paul has to show that his interest in the information outweighs the public interest in the gathering and dissemination of news, including journalists' concerns. In the motion, Paul argues that his interest in the communications outweighs the public interest in Coffeezilla being able to withhold them because he says evidence about a publisher's motivations for making particular editorial choices can be powerful proof of actual malice. And we've talked about this many times before in this case, but Paul is a public figure. So in order to win this case, he does have to prove that Coffeezilla acted with actual malice. And that is a very high hurdle to overcome. Essentially, he has to reach inside Coffeezilla's head to find evidence that Coffeezilla knew that what he was saying was false or that he was reckless as to the falsity of the statement. That, of course, is assuming that Paul shows that the statement was actually false in the first place. And I will say, to Paul's credit, if there are communications that show Coffeezilla telling his editor, I know Paul isn't a scammer, but I want to say that he is anyway, I mean, yeah, I would agree that that's a pretty strong evidence of actual malice. But the thing is, Coffeezilla, once again, says not so fast. See, apparently the 2 sides agreed to have a particular independent third party review a bunch of information basically for this exact purpose, to evaluate whether or not it fell under a particular privilege or whether the other side was entitled to it. Now, this is interesting to me because most cases in civil litigation don't have a third party independently reviewing these things in discovery. It's really for only when the discovery stage really gets contentious on like a continuous basis that they ever use one. That's because it's obviously an extra expense. It's another person to be submitting things to and trying to get things back from, etc. But the reason they might want to use a third party like that is because otherwise they're bringing this to a judge to try to resolve. And judges generally don't like to be that referee unless they absolutely have to. So when you're in litigation and you're in the discovery phase and there's like request after request after request is having to be argued about again and again, sometimes it might be worthwhile to have a third party that can look at things much more quickly and thoroughly and who isn't necessarily annoyed at having to do the job and where both sides can maybe, hopefully resolve the issue a little bit more quickly. So apparently in this case, the 2 sides have this independent third party who's been looking at these requests, the information that's being fought over, and has been making some determinations so far. And according to Coffeezilla, the information that Paul is trying to get now was already put in front of the independent third party. Specifically, Paul had previously asked for communications that showed Coffeezilla was aware of Paul's alleged good faith with regard to Cryptozoo. And so apparently the third-party evaluator said that after looking through everything, there was nothing in the communications between Coffeezilla and his team that was responsive to their request. In other words, 404 not found. Coffeezilla, his editor, his graphic artist, none of them said anything that showed Coffeezilla had some kind of awareness that Logan Paul was acting in good faith related to Cryptozoo. And so Coffeezilla says there's nothing there, and the third-party evaluator already told us this. But in response, Paul says essentially there's a difference between what Paul was requesting before and what he's requesting now. Before, he says, he was just requesting communications about Logan Paul acting in good faith. And so the third-party administrator was responding to that. But now he says he's asking for communications that would apply more generally to the element of actual malice. And so essentially what Logan Paul is saying here is that what the third party originally said about the previous request doesn't necessarily fit this particular request because it's more broad. Now, Coffeezilla argues here that there's no difference because Paul has been saying, I was acting in good faith, and Coffeezilla knew that, and that's why he acted with actual malice. In other words, Coffeezilla is saying Paul's been talking about his good faith and Coffeezilla's actual malice to mean the same thing as one another, so they should be treated as the same thing here. Now, from my own perspective, I actually, once again, do agree with Paul that there is a difference between saying Logan Paul acted in good faith and Coffeezilla knew that, and Coffeezilla acted with actual malice. That's because actual malice actually is a bigger umbrella. Sure, it covers the same territory as the argument saying Logan Paul was acting in good faith and Coffeezilla knew it. But it would also potentially cover other communications too. Like if Coffeezilla hypothetically said, I actually don't even think that this was a scam, but I want to go ahead and say that it was anyway because that's going to drive clicks. But Coffeezilla might have a point here if he says that all of these communications were already put in front of a third-party evaluator and they found nothing responsive to these earlier requests. That doesn't necessarily mean that the third-party evaluator wouldn't find something that's responsive to these new requests. But it really has me wondering why the third-party evaluator wasn't used for these requests also. Now, don't get me wrong, there's really nothing in any of the arguments either way that points to why they didn't. So I can't even say that I see something maybe strategically other than the possibility that maybe Paul's legal team was just worried about missing some discovery deadlines, and so they decided to just get this in front of the judge instead. Anyway, but then there are the last two factors here. For the fifth one, Paul has to show that the request isn't being used to obtain peripheral, non-essential, or speculative information. And finally, he also has to show that the information is relevant and material to the proper administration of the official proceeding and is essential to the maintenance of a claim or defense of the party seeking it. In my opinion, those last two factors are kind of addressed with what I said earlier in this video. In my opinion, they are in fact aimed at what Paul believes would help him prove actual malice, and that is pretty central to what he has to prove in order to win. Coffeezilla says otherwise, of course, because he says this third-party evaluator already determined that the communications in question wouldn't show actual malice because there's nothing there. Now, this is the part of the video where I cut in during the editing stage with the information about the judge's decision on the matter. Yeah, I know. At the very beginning of this video, I said, I have no idea how the judge is going to decide on this issue. And while I was saying that, I apparently completely missed the fact that the judge already made a decision. Minor details, right? It's not really all that detailed. So most of what was argued between the two sides is at this moment kind of just left without an answer. But what isn't left unanswered is that the judge ended up denying Logan Paul's motion. Here's what he said in an order that went over a number of other issues that have been pending before the court in this case. Based on the information in the motion, the arguments of counsel, and the parties' previous filings and negotiations on the matter, the court finds that plaintiff has not established that in this instance, the interest of the party subpoenaing the information outweighs the public interest in gathering and dissemination of news, including the concerns of the journalist. The denial of this motion is without prejudice to reconsideration based on new information, if any, obtained since briefing was filed on this motion. So there you have it. Nothing about the third-party evaluator, which I personally thought was kind of important. The judge basically just said, Logan Paul hasn't shown that his interest in this information outweighs the interest in protecting this information for the purposes of journalism. Beyond that, he didn't really say why, didn't give any more detail. It was a little bit surprising to me, but hey, this is called the practice of law for a reason. And so 10 years into being a lawyer now, I'm still yet always open to the possibility that there is something left for me to learn. But those are my thoughts. What do you think? Does this seem like a situation where Paul might be entitled to the group chats between Coffeezilla and his editor and his graphic artist? Or should they be protected? Do you think that there is a difference between Logan Paul arguing, I acted in good faith and Coffeezilla knew that, and then saying, Coffeezilla acted with actual malice? Let us know your thoughts in the comments down below. Otherwise, I hope you enjoyed this or at least found it interesting or informative. And if you did, I would love it if you would hit the like button. It does help us with the YouTube algorithm gods. And if you're new here and you want to see more coverage of crazy cases and interesting legal topics, be sure to hit the subscribe button and the notification bell so you can find out when the next video is out there. And if you're really enjoying the content and you want to know how to best support the channel, consider becoming a member of Byte Club. You can join either through YouTube memberships or by becoming a supporter on Patreon. Links to both in the description below. Otherwise, see you in the next one.